Posso? Andiamo.
Sì, questo
Mi serve per caso, ma lo accendiamo. Mi accende. Lo accende, invece lo spengo, ti prego. Okay. So it's a great pleasure for me to open this conference. The result of a collaboration between the university, Sapienza University and Mercatorum, to fostering open scientific dialogue on high relevant topic. But this event is also a celebration of a personal strong friendship with my friend Stefano, and this friendship continues through Martina and Fabrizio, and an important expression in ELLIS, the Association of Young Scholar, European Young Scholar, or Labor Law. The Southern Europe coordination of ELLIS is a warm passage from Fabrizio to Martina in very, and they continue to collaborate. It's very interesting for me to see two young scholars to collaborate in this way. It's publicity. During the ESL SSL World Congress of Labor Law in September, was the new president, Jean-Michel Servet. We are honored to welcome today. The ELLIS network provides an important space for young scholars to connect with the support of a regional coordinator, and Luka Misic. I warm thank you for being here today. But the topic of this conference, international corporate social responsibility, is an urgent importance because the recent adoption of European directive on due diligence has demonstrated the potential legal tools to enhance the protection works human rights in the global value chain. But it's not strange for me. Only 9 months after the directive, Commission presented the Commission Omnibus Simplification proposal to, it's not approved, but to reduce the right. Is normal, I think. So today, we're proud to welcome the additional panel of speakers whose experts bring both international perspectives for this event, but also we have some young scholars, and I'm very happy to host them because they respond at our call for structure, but today they presented the works today here. So I think in this conference we can learn something very interesting about this topic. I am very happy to begin today this conference, and I hope this is the first collaboration with our friend, international friend, and friend of the Sapienza University. I think. Yes. Thank you very much, Stefan. Okay, bye, Martina.
Thank you, Professor Moscella, for this introduction. And I really want to thank also Professor Fabrizio Ferrara, Professor Fabrizio Bellomo for Stefano Bellomo, sorry, for organizing this seminar as scientific coordinator and for their contribution to Alice during the years. And as a young scholar, I had the opportunity to participate in several events organized by Alice, and I really appreciate the work of the coordinator. So after Fabrizio, I would like to thank Bastron Boots, who was not here today due to prior commitments, but he's the coordinator for Northern Europe of Alice, and of course Luka Misic, who is here today not just as a coordinator, but as one of our speakers. And thank you to all the speakers and to all the participants, if present also, who, those who are following us remotely. And thanks to the colleagues from Mercatorum University and Sapienza University who participate in organizing the event. Corporate social responsibility remains, of course, a current topic, both for companies, which today are attentive to be compliant to the measures provided by European Union hard law approach, such as due diligence or sustainability reporting, and for different stakeholders. The aim of these 2 days is to provide a broad overview of the issues of corporate social responsibility, considering the various phenomena involved in this topic, such as global value chains, and the regulatory weakness that still today justifies the centrality of the issue of CSR, intended as a voluntary approach of companies. The European Union's regulatory framework currently represents one of the most interesting evolving scenarios, but uncertainties remain. Indeed, the intervention of the Omnibus package, which aims to simplify the obligation of companies, calls for new reflection on the effectiveness of the instruments adopted to the date. So, without taking up more time, I leave space to the speeches of our speakers. In this first session, we will have with us Professor Jean-Michel Servet, Professor Samantha Belluti, and Professor Luka Misic. Then, after a small coffee break, we will have the contribution of our young scholars. So, for me, it's now a pleasure and an honor to give the floor to Professor Jean-Michel Servet. He's one of the leading experts in international labor law and one of the pioneers in the field of the relationship between international labor standards and corporate social responsibility. So, Professor. And of course, I have to say that you're the president of the International Society for Labor and Social Security Law. So, for those who are...
Thank you. Thank you. Martina, signore e signori, permettetemi innanzitutto ringraziare Marco Boccella e Martina Bossetti per l'invitazione e per l'organizzazione del seminario con il professor Stefano Bellomo e la Sapienza. La Società Internazionale del Diritto del Lavoro e della Sicurezza Sociale, che presido, vi dà tutto il suo sostegno e sempre un gran piacere collaborare con loro. Well, let us move to English. I will feel more comfortable. I will speak about corporate social responsibility and the International Labour Organization, the ILO. The globalization of exchanges has significantly decreased the regulatory power of the state, that we know, especially in the case of transnational enterprise. And it has consequently decrease the capacity to regulate of employers and workers' organizations. And consequently, again, the capacity of the International Labour Organization, which is constituted by the three of them, to have an impact, especially on transnational labor relations. That's an explanation of the difficulties facing not only the ILO, but the whole UN system in particular, whose structures and mode of action continue to depend on interstate relations. Another problem is that most of the international labor regulations were elaborated with the Fordist system of production in mind, while we are facing now a completely different system with fragmented production. Well, those elements and others push NGOs and trade unions to promote and to encourage enterprises to adopt kind of ethical codes of conduct. And indeed, the enterprise has also their advantage to do so. Well, many have a social commitment. I worked one day with IKEA, that was clear. But also, they are afraid of bad publicity. And they try to take a comparative advantage by the way they are treating their staff, and especially the staff of their subsidies. Such development, of course, put into question the ILO standard-setting activities. And what I would like to discuss with you, you are welcome to objection and questions, is the legitimacy and the efficiency of the transnational labor regulation. And I will focus on two elements. First, the scope and the content of the regulation, and then the implementation, supervision, and efficiency. Scope and content. Well, the ILO conventions and recommendations deal with almost all aspects of employment and labor law and social security. On the contrary, of course, the scope and content of the provision contained in the codes of conduct and other private initiatives are limited. They are, first of all, limited by the objectives of the enterprises. And the objective of the enterprise is to make profit. It's normal. It's their job. But then, of course, there are some criteria. And there are regulations which may favor it or not to disturb it, and others which are less. Convergence, of course, safety and health at work. Discrimination of gender, especially. Determination of wages, many times, to be transparent. Divergences, salaries, facilities of dismissal, etc. So you have both, the one accepted, the one rejected. And I observe, going through the codes of conduct, that freedom of association, as such, is almost never mentioned. Representation of workers, yes. Freedom of association. Well, second, I would say, limitation. The labor regulation do not focus only at the enterprise level. They do it above, on question of employment creation, on question of training. The main level to discuss it is either sector or national. That is not for the enterprises to do so. They may contribute, but nothing more. And finally, of course, the scope, the diffusion, is also more limited, to the point that I met some enterprises, multinational, they were not willing to explain publicly what is the content of their code of conduct, but because they wish to have a comparative advantage vis-à-vis the others. Not to speak of cases when their provisions are disturbing the government policy of development. It's not frequent, but it exists. So, okay. Supervision and efficiency. Well, you know, or we can refer to my book and other books on the procedure for supervising the implementation of ratified convention and recommendation. Basically, you have a complaint procedure and a reporting procedure, and both has a body of independent experts, legal experts, and another, which is a tripartite body, which is, I would say, the political relay to the countries. Problem? The conclusions of the supervisory bodies are not enforceable. They are recommendations, conclusions, except a final recourse to the International Court of Justice. But it never happens in that field. The governing body of the ILO and the conference themselves may take sanctions, but they never do that, or very rarely. I could mention recently example of Myanmar, Burma, and on Belarus. But they are reluctant to do so. Why? For a simple reason. The ILO could not send a blue helmet to a country, to China, to implement freedom of association. It's in the present stage of the international society, it's not thinking. And still a little less now than, I would say, 5 years ago. This being said, the successes of the ILO procedures are not bad at all. I would say they are much better than what I was expecting when I joined the ILO as a civil servant at the beginning of my career. It's true, but it's true at national level also, that the government are more respectful of the regulation in speech than in actual practice. But I can mention a number of cases of trade unionists, of employers' leaders released from jail because of the ILO action. I could even mention people who were saved because of the ILO action. I worked in the Freedom Association Secretariat for a while at the beginning of my career, and I had a case to defend a Brazilian trade unionist called Lula, and through my action, he was put out of jail. It was not me, it was the ILO, but I was the one doing it. So that's when he came to Europe the following summer, he was asking to thank everyone. And the people say, well, you should also go to the ILO. I think this young guy, because he worked hard on your case. So he came to my office. Unfortunately, it was July. I was in holidays. So I had a letter from Mr. Lula thanking me to have released him. But that's an anecdote. But and I may say that my colleague and myself, especially at time of dictatorship, we have saved life. And that's really the best of the ILO. But of course, there are also a number of people dismissed which were reintegrated, and law which were changed, including in Russia and in USSR, and in Russia at the time of USSR, I would say, and in USA. So, result, yes, perfect, not at all. And the ILO do it through I would say, dialogue and cooperation, more than sanctions. With the technical cooperation, of course, for technical convention, social security convention, for example, technical cooperation is necessary through soft law and through conciliation. I myself was lucky enough to do a lot of conciliation between states or within a state. But let us move to the corporate social responsibility and the codes of conduct. Enforceable or not, this code of conduct? We have first to see if there is a real commitment and not just a declaration, which was also the case a number of times. If it's a real commitment, we have to see if it's based on a collective agreement with trade union, possibly with NGOs, or if it's a unilateral commitment. When it's an agreement, you can follow, see what is the law applicable, and then see what are the effects. Normally, in addition, you have in the agreement itself a control procedure, an internal procedure. Concerning unilateral commitment, well, you have to see which kind of law we are dealing with. In the country influenced by the Napoleon Code, the unilateral agreement is compulsory. Yes, enforceable. In UK, I was told that you may consider that it becomes obligatory through the implicit integration in the contract of employment. I will be corrected later on if it's not really the case, but I was told by English colleagues. And in the States, there are some cases more about environment than labor, but for both, it's considered as an unfair labor practice to say something and to do the contrary. Internal procedure, because it's still quite ambiguous to see if it's really compulsory or not. So there are also internal procedure, and then everything depends on the quality and on the independence of the auditors and other inspectors. I have a lot of anecdotes on both sides. Well, this being said, there's another problem, and I will call it the Trump effect. You cannot imagine the number of multinationals who feel how more at ease. And they start to flexibilize their practice. Not the code itself, but the practice. They say, well, time has changed. Time has changed indeed for the European Union too, as they have a draft omnibus directive to flexibilize the system. So there is a political vision behind the private initiative, more liberal, more interventionist with ILO rules. I also draw the attention that corporate social responsibility is a private international field, while ILO is public international law with all the differences. If I make a picture which is not totally positive for both, is to conclude, I have still some minutes, to conclude that actually one could not replace the other, but they may complement them. They may help each other to go to this social objectives. The ILO influence indeed the private initiative in the content. Many times they refer implicitly or explicitly to the ILO Declaration on Fundamental Rights at Work and to others. In some cases, violation of the code of conduct came from the observation or the comments of the committee of experts of the ILO. It's not frequent, but I have cases, and for the solution, which is more interesting, sometimes they ask informally the ILO for help. And I did myself, I had some personal experiences. The collaboration is not easy. Why? For several reasons. The first reasons are that the multinational do not fit within the ILO structure. ILO is based on employers, workers, and government delegates, but the employers are national employers. And the multinational are not so ready to go and to join national association of employers for various reasons, including the parent enterprises. Why? Because they are, generally speaking, multi-sector. Why? The employers' associations are built mainly on sectors. That's one reason. I have example, IBM left years ago the German Association of Employers for that reason. And actually, they have their own network and their own meetings amongst themselves. Second, the law firm which advised them, and by the way, the employers group as a whole of the ILO also, is not especially social oriented. The people are coming from business school and from university with a clear market orientation, and they are not really very positive about social regulation. And third, ILO lacks means of pressure with them. When you have international investment law, that's perfect. Not respected, cut the money. When you have, I would say, the mobilization of the shame, genocides, trafficking of human beings, even child labor, it's not too difficult to obtain something. But when you speak about working conditions, the duration of work, that's very different. And then it doesn't work in the same manner. So the reaction of the ILO was, let us use soft law. The tripartite declaration on multinationals of the ILO, which is a kind of model codes of conduct. The declaration of 1998 on fundamental right at work, okay, a model, a resolution on the production chains, more recent, and then, which is interesting, technical cooperation program together with big enterprises, or even agreements under the auspices of the ILO. It was the case after the big accident of the Rana Plaza that you may know. More recently, the ILO was asked to legitimize an agreement between General Motors and the Mexican steel workers union in the South, in link with the free trade agreement between the states, Mexico and Canada. And there are informal contacts. There is what is called a help desk in the ILO, but mainly my experience is that when they have a problem, they do not go to the help desk. They call someone they know in the ILO and say, could you help? And if I have time, I could give you an example of that. And it worked. Could we do more? Of course. And I would say that we could do more in the field of mediation. I think transnational labor relations are not yet mature for I would say, a settlement of dispute through jurisdictions. And it would be more efficient to do it with conciliation. You have people with the capacity to conciliate in the ILO. They have both the neutrality and also which is not so frequent, a kind of, how to say, capacity to know what is possible and what is not possible for the developing countries. And with that in mind, you may create the trust with both sides and go ahead. I could continue like this for a long time, but I think I have already spoken too much. Thank you, Martina.
Thank you, Professor. I don't know if we maybe leave the space for questions at the end of the three speech, but I think we are in time. So if someone has some questions, maybe you can think about it during the next speech, and then
Stefano?
Okay.
Thank you so much for this really interesting introduction to the main issues that we're going to examine in more detail, particularly in relation to sort of the limitations of the ILO. I was wondering whether you had any specific views in terms of representativity as well. So the representativity of social partners within the ILO, vis-a-vis, for example, workers in the informal sector. Because that, my understanding is that is one of the criticisms made against the ILO, that it's not representing all workers because of the change in the landscape. We live in a globalized economy, and many of the problems, the issues that we're going to talk about today, in fact, concerns those who are not represented. So I wondered whether you had any thoughts about that.
Of course. It will be another lecture. You have two different problems, I would say. One is, should we involve the NGOs? All kinds. Yes and no. But if you think of it, it will be better. But the traditional partners are quite reluctant. More the employers than the workers, by the way. Both, but when you think of the NGOs, they are not, their representativity is quite limited. Then think of Greenpeace, or others. Well, you have some activists, they are excellent. They are much better than the trade unions with media, for example. But in terms of representativity, the trade unions are still the ones which are based on principle of the freedom of association and democracy in almost all cases. And so they have a legitimacy that the others have not necessarily. The main problem is the informal sector, the informal economy. But how to introduce it without having representatives? The ILO has do a lot to try to promote freedom of association in the informal sector with successes. I can mention successes in India, in South Africa, in Ivory Coast, in Peru, and Argentina. I was wondering about Brazil, but I have no example in mind, etc. So it exists. But of course, they do not represent the huge majority of the informal economy, and the informal economy is increasing, not decreasing. Have I answered?
Yes, no, thank you so much.
Stefano?
Yes, Jean-Michel. Thank you for your wonderful speech. And I want to ask you if you think, I could guess that the role of the ILO could be very crucial in shaping, as you said, the contents and the scope, the meaning, the whole meaning of corporate social responsibility. Because each corporation could be relatively free to define the boundaries, so the scope and the contents of the CSR, and also the enforceability is very uncertain in relation to each national juridical order. But there is also another order of sanctions that we could not ignore. That is the reputational sanction. The reputational sanction that could be a real risk for the big corporation, but it depends by the several forms of responsibility that could be identified specifically in each corporation code. So I would ask you if you think that ILO also in strengthening these reputational order and sanction could play a role in, especially in defining the various meanings, the various forms of social responsibility that could be not imposed, but strongly recommended to adopt and to control and to check by each corporation.
Yes. Technically speaking, ILO could adopt a corporate social responsibility convention or recommendation linked, and the states of the parents enterprise in particular could be linked, etc. Technically, yes. Politically, it's out of question. There is no majority. Look at how is it? The guiding principle on human rights of the United Nations. They tried for years to put it into a convention. No way. And I am skeptical that it could arrive soon, especially with the change in the world, I would say. Not even. So that's not the way. But I will give you just a personal example. It's not to put me in the picture, but because I have the experience. I received once a telegram by an NGO saying that one of the global shoe factories has used child labor in Vietnam. Could you do something, sir? Technically, no. Multinationals are not members of the ILO, and the complaint comes from an NGO and not from a trade union. But I think I will try. I called the big boss, say, could I? He said, okay, try. I will criticize you if you fail, but okay, try. And I also make sure that the employers group was not against. And then same answer, okay, do it. So what I did, I asked my secretary to call the DRH, the Director of Human Resources of the firm in the States. And go to her twice. The third time I say, okay, I take the phone myself, and to the receptionist or whoever, I say, well, I take note of the answer, but please, I will inform the NGOs that I mentioned the problem, and I will mention to them your answer. And if they publicize it, it's there. It took less than 1 week for all the families of the children to be compensated for the damages, and it was stopped. So purely informal. I never mentioned it officially for obvious reasons, for my own credibility and the possibility to do so. And it's not the only case. That's my answer. Just take before leaving.
Anyone else? No. Okay.
Go ahead.
So thank you, Professor, for this view on the potential of the ILO, but at the same time, the weakness of the international labor law. So I think that we can go on with Professor Samantha Velluti, so change a little bit the perspective and talking about the European measures and their capacity to fill this regulatory gap. We will see.
Yeah. Is there a password?
Yes. Non credo. Per le
Belluti.
Allora, metti in presentazione e poi quella faccio sul basso non è.
Ah, passo, non al lato.
No, no, faccio questo.
Ok.
Togliamo questi tre. Esatto.
Perfetto.
Ok. Ah, aspetta. Facciamo vedere anche quelli a caso. Sono video nel...
No.
Non lo vediamo.
No, l'ho tolto, ce n'avevo ma mi fai sapere magari 10 minuti prima della fine, perché io tengo to digress.
Dimmi. È troppo tardi.
Ok. Mi raccomando che il microfono sono a casa non ti riesco.
Okay, well, first of all, I also wanted to start with thanking Martina and Professor Marcella for inviting me here. It's exciting for me also because I am from Rome and I studied at Sapienza. I used to study in the library in Gaetani, so it's really fantastic to be here and to be talking about these really important topics. And I think it's, I mean, some of the points that Jean-Michel Serret has raised are really fitting with what I'm going to say, and I will try to avoid overlap, but I thought of providing sort of the context as to why then we've moved to the two legislative instruments of the European Union. So forgive me if there is a bit of overlap. But I want to start with sort of the premise. What is my position? Following also again what Jean-Michel Serret was saying about the ILO, and we started identifying some problems, which I think can be summed up with the fact that it's very much focused on state action. And I would add perhaps that we're living in a crisis of multilateralism and also of universality, right? So universality of rights in particular, and we know the problems in addition associated with
labor rights and social rights. So my premise here is borrowing a concept from Professor Dahal from the University of Tel Aviv, who's developed with others this concept of shared responsibility, which is based on the ideas of morality. So identifying a moral justification for developing an international labor governance system. And so here I reproduce a definition which I think is helpful to use. So this idea of responsibility for protecting and promoting labor standards in global supply chains, which is our challenge nowadays, as Jean-Michel was saying earlier. We've moved from a Fordist system to a fragmented system of production. So the argument that I want to make is that rather than talking in sort of black and white terms and saying it's either one approach or the other, we should have one actor or the other, it should be a mixed, a hybrid system with the involvement of different actors that are directly or indirectly involved in the production process, but also in terms of governance, we need to, in my view, combine hard law with soft law. Obviously, the challenge is identifying how we ought to do this. And so the big questions, I've been examining these issues also from the point of view of governance, relationship between constitutionalism and law and regulation, really is maybe to identify, as, for example, the EU has done and tries to do, to develop partnerships, right? So develop partnerships with the ILO, for example, with the OECD. And in fact, one question, sort of a big question mark, is also, how do we then link this with, for example, global framework agreements? So I think the challenge nowadays is really to identify how we ought to do this. This is really to outline how I'm going to present some of the issues. In the interest of time, I might really skip some slides, but I hope to be able to return to them during the debate later. So as you can see here, I've chosen as a case study, so I've written a paper where I examined the garment sector, mainly because, as we know, that's also where we have a lot of empirical evidence of the kind of issues that the law, broadly speaking, is trying to address. Which in turn, so this fragmentation in production, I think also explains the fragmentation in terms of regulation, right? And that's something that I will touch upon briefly later. And the problems that we are examining today have been impacted severely also by the pandemic. I think that's something that we shouldn't forget. So pre-existing issues have been exacerbated. And so my analysis of the EU regime is situated in this context. So I think the context really is important to understand where the EU is coming from. I have sort of mixed views about the EU. So, there's a lot of praise, but obviously there's also the other aspect. Again, legitimacy was mentioned earlier, and I think legitimacy is, again, an issue as well here. Why is the EU doing it? Well, because it has to sort of justify its actions externally. Why is it trying to sign agreements with countries that have abhorrent record, and a record of abhorrent human rights abuses? And so, as I was saying earlier, I'm going to use the garment sector as a lens of analysis to see how the EU is trying to promote, or whether it does, to what extent, a decent work agenda. So this to illustrate the relationship between the EU and the ILO, among others, using these two legislative instruments. And so Clearly, it's early days to say, you know, whether or not they have any added value. Before the omnibus package was mentioned, preceded already by Draghi's report. So there has been a push for deregulation rather than strengthening sort of a governance system. So I like to use infographics or images also to illustrate the problem. And these, I think, show the complexity of global value chains and global supply chains. And they clearly indicate the fact that what we have, besides a parent company, are a series of employers scattered all over the world. And I always particularly like to use the example of Nike, Nike shoes. So I'm referring to a report of 2018, which gives some data about how many countries are involved, factories and workers. And just to give you some figures, 42 countries, 542 factories, and 1,023,000 circa of workers, out of which 7.4% are migrant workers, 59.2% female workers. And this is really to illustrate the challenge that we're faced with. And so moving to the garment sector, the Rana Plaza disaster was mentioned earlier. So here I've included a picture. I don't think it needs any description or any words. You know, more than 1,000 people died. And as some of you will know, many of those were children as well. I mentioned earlier that the pandemic has exacerbated existing problems. So what has been happening is that retail giants have been sort of passing on the baton to suppliers in particular. And they have used force majeure arguments to say, oh, sorry, you know, we can't, not even sorry, you know, just saying, we're not going to buy your garments. No one is buying anything, so goodbye. And this obviously has had a domino effect on the on the workers. Now, here with this slide, I'm sort of mapping out what we have more or less. We mentioned just a few minutes ago the UN guiding principles, the limitations of the UN guiding principles. And even from a labor rights perspective, you know, we can argue they've been in place since 2012, and what we've seen instead is an increase in forced labor, for example, rather than a decrease. Also the ILO Tripartite Declaration, the OECD multinational guidelines, and so on. So what we have is corporate social responsibility mechanisms, codes of conduct. You can see also I've included some pictures of labels. More recently, what we have are also voluntary sustainability standards. So there's been a focus which tries to combine labor and environmental standards. But even there are problems. So for example, there have been some studies in relation to voluntary sustainability standards in some countries, for example, such as Africa. And the problem there is that in order to carry out, to get this certification, they have to pay a lot of money which they don't have. So, I mean, this is just anecdotal, but just to show even the problems, some of the problems that I encountered with soft law instruments as well, which are, there is an attempt to tie them in with core labour standards. But as was mentioned before, as I will try to show, the problem is not in relation to labour standards as such. I mean, obviously, for the purpose also of the workshop, of the conference today, we're just focusing on labour, but the problems are interconnected, right? So more recently, we've also seen legislation on public procurement, on investment law, trying to tie in the pursuit of the respect for labour rights. So Jean-Michel Servet already discussed in detail what corporate social responsibility is. So the main problem, so I'll skip the definition, but I think the main problem here is holding corporations accountable. So my interest is to see how can we provide access to justice, to judicial remedies for victims of labour rights abuses. So there have been some sort of alternative models presented. In the previous slide, I was referring to corporate political accountability to stress issues of corruption, for example. But again, as was mentioned earlier, the overarching problem is that what we really need is a change in corporate purpose. So it's a corporate purpose that really has to change. And that is because we know that what corporations really trying to do is to rely on corporate law and the separation of personality in particular to avoid any accountability. So, as I said, what we need is a system which tackles these different aspects. So that's why sort of here I say what labour law got to do it with it more in a sort of polemical way to say that really if we don't change the overarching issue, then any attempt to ameliorate things on the ground will not change. Now, again, I want to, in the interest of time, I want to move on. But again, here I'm using some images to show some very recent developments at EU level, which indicate, as Mr. Servet was saying, about the Trump effect. So we've seen it, it's been quite rapid. Already it was very difficult to adopt, not so much the forced labor regulation, because as Jean-Michel Servet was saying earlier, it's easier to agree on forced labor or child labor, harder to agree on working conditions. So this was the context to explain this move. So the idea is to create a level playing field, to avoid regulatory chill, so that, for example, corporations cannot say, well, if one country is doing it, I can move elsewhere. We've seen already Google doing it with Ireland, for example. We could mention Amazon for that matter. And we should say that, you know, the EU is following suit, right? I mean, it's been mentioned earlier, there are some due diligence laws at national level, but those are the problems. I'm not sure I'll be able to examine them, again, for reasons of time, but as I said, the EU is following suit rather than being a complete innovator. Building on the human rights due diligence guidelines, there are problems with the guidelines. It's not just so much the fact that they're soft law instruments, because we've seen that soft law can have its advantages, but the problem is that, again, they're principally addressed at states, and that's also one of my arguments with the directive. I also challenge the use why directive when that allows diversity between countries. I think it would have been preferable to have a regulation such as the forced labor regulation, but clearly, again, that was the fruit of compromise within the European Union. So I mentioned that the EU is following suit. Now, there are differences. The Modern Slavery Act in the UK has been in place for some time. The problem there is that it mainly only includes a disclosure obligation. and there's evidence suggesting that it's being used as a ticking box exercise. And so that suggests that there has to be also a system of enforcement, such as the Netherlands child labor due diligence law. But most importantly, again, my concern is seeing it from the victim's perspective. There has to also be a system of liability. And that also has been subject to heated discussion. But these are all recent laws, as you can see. So what we say is very theoretical. I think perhaps in France's case, the duty of due diligence, I haven't myself conducted research on France, but so I'm relying here on Jeffrey Vogt's paper, where he examines some of the laws on due diligence, and he mentioned a case, I believe it's the only case in France, the Sud PTTV La Poste case, and this concerned the employment of undocumented migrant workers by subcontractors. And the court ordered La Poste to supplement its vigilance plan with a risk map and a warning mechanism after consulting the trade unions. However, there was no remedy ordered for the aggrieved workers. So I think this is the challenge that we're faced with, that I think, in my view, from what I know so far, also examining some cases in the States, in the context of environmental law, there seems to be reluctance also on the part of the courts, particularly tort law cases, right? There have been attempts to try and rely on tort law, and the judges find that, you know, there's not sufficient sort of causal link between the damage and the act of the company. So just to give a very quick overview, and perhaps highlighting the problematic aspects, the personal scope of the directive. I'm sure most of us are aware of the fact that it only touches very few corporations, because it targets very large companies. So, for example, the European Coalition for Corporate Justice has said, well, what about medium size enterprises? And in fact, there has been evidence that even in the UK, Boohoo or Shein in China, for example, well, Shein is much bigger, but the point that I'm trying to raise here is that even small companies can commit serious labor rights. So that's one aspect, that, you know, the personal scope of the directive doesn't consider small and medium enterprises. There's also a problem in terms of the material scope. The financial sector, for example, is not covered by the directive. And to some extent, that can, in my view, is also partly explained, even though the Commission carried out one of its biggest consultations before adopting the directive, is the legal basis. So as you can see here, the fact that it's been conceived as an internal market measure. So I think that, as such, is problematic. On a more positive note, it has arguably an extraterritorial reach, because it covers also non-EU companies. So it's not just being established in the EU, but also if they operate in the EU, they have to comply. So that is on the more sort of positive note. Now here I list the various types of due diligence obligations. Again, on the plus side, there's reference to remediation, but I'll return to that as a problematic aspect in a moment, if time allows me. I think, okay. But what I want to highlight is that it's an obligation of means, not of result. And that's something that the EU tends to do also in other spheres. So, for example, I've been looking also at how the EU is trying to inject a sort of a sustainability dimension to its trade agreements. And even there, there's reference to striving to, rather than, you know, having a clear-cut obligation of results. So that makes it difficult, again, to enforce measures. Clearly, that is an issue of perspective. If you see it from enforceability perspective, that's a minus. But I do appreciate that soft law can have its positive impact in terms of gradually introducing change in countries where there isn't such a culture of, for example, human rights or even democracy in some instances, even though they might use other terms or have another approach, other philosophy, but not sort of the more westernized understanding. I say here it's not sufficiently victim-based. I cite as an example Article 29, paragraph 3 of the directive, which refers to compensation. So yes, compensation might be good, but if, for example, it concerns people who are trying to form a trade union, and we're dealing with a violation of their freedom of association, then compensation is not exactly going to be a meaningful way to address that violation. It's also problematic if we want to sort of compare it to the UN guiding principles. As I already mentioned, the personal scope, because the UN guiding principles don't distinguish, they cover all corporations. But the other very controversial issue, and this has been discussed quite a lot in academia, is the so-called business relationship that is referred to in the directive. Again, it's much narrower in scope than the UN guiding principles. So there have been some sort of recommendations in terms of changes. We know that now it's been finalized, but there's still scope for change because the directive is subject to review. The Commission has to review it every top number of years. So my hope is maybe once Trump is not around anymore, maybe there's some hope for returning to sort of pushes towards more regulatory approach, broadly defined. I'm not suggesting, as I said, hard law is always the solution. But one proposal made by Bueno and Bright, for example, has been to focus on a combination of strict liability with due diligence defense. And that would make it much easier in terms of the burden of proof, because that can be an issue, right? Also in terms of if you don't have the resources, the financial resources, we know that these are cases that can last for years. I think it's important to make that easier. I've already mentioned the fact that the instrument as such is not ideal. We know directives leave a lot of margin of maneuver. And so that will create, I think, problems in terms of a proper application to obtain proper results. And then I also suggest sort of a mainstreaming approach. It's not just in one sector, in one policy area. We have to sort of try to embrace a due diligence approach across the board. Now, I have carried out sort of a bit of a comparative approach to see where the EU is. And I must say that the EU is a front runner in this respect. In the US, the only comparable act is the California Transparency and Supply Chain Act. And this is more, however, again, closer to the Modern Slavery Act in the UK rather than the corporate sustainability due diligence. More hope is the bill of the New York State, the Fashion Sustainability and Social Accountability Act, because this, once it enters into force, it wouldn't distinguish between corporations. It also has a much broader remit in terms of the products and the services in the fashion industry. Okay, this was going to be a premise to decent work to move gradually towards forced labor, but I appreciate that I won't have time. But I think the only point I'll make here is that the EU is trying to really strengthen the partnership with the ILO, building on the two ILO conventions on forced labor and abolition of forced labor. And here I sort of map out what the EU has already been doing. There are problems, particularly with the Human Rights Trafficking Directive. The problem there has been, again, I question the instrument. If you use a directive, you're going to have different laws, a very messy situation, and that's what's happened, particularly because some countries have not focused on the protective element of the directive, so not on the victims. They actually ended up criminalizing the victims. So anyway, this was the premise to the forced labor regulation. So as I said, I will move on in the interest of time to the forced labor regulation. So please bear with me. So also clearly covering the child labor convention as well. So I think the main point that I want to stress about the forced labor regulation, also in comparison with the directive, whereas the directive is very sector specific, and it also selects the corporations or the companies that are covered by it, there's no such distinction in the forced labor regulation. The main focus is on the products. So the purpose of the regulation is a prohibition on allowing products that have been made with forced labor into the EU market. So once, after a two-stage investigation, there's evidence suggesting that they have to be destroyed, or the company has to destroy that. And there are some precedents in the US and also Canada. As you can see here, I will mention the US in a moment, always if I am allowed. So I mentioned the two-stage process. Now, what is my main argument in relation to the regulation? Well, first of all, that again, we seem to have a very high threshold when it gets to the burden of proof. Also, the problem is that it's not sufficiently victim-based, and there is a risk that the way that the regulation has been drafted, due diligence might be used as a shield by companies against investigation, i.e. saying, well, you know, I've already complied with my due diligence obligations, so you don't need to sort of carry out an investigation. And as I said, I think the main point there is, rather than the victim, the issue is on the product. Now, just to compare it with the US context, I think I will focus in particular on the Uyghur Forced Labor Prevention Act, to sort of compare it with the EU forced labor regulation. First of all, as you can see, it focuses on China only, on a particular region where the Uyghur live. And as you can see here, there's a rebuttable presumption. So it's up to the importers to demonstrate that they haven't been made with the forced labor of the Uyghur population. But again, we see a very high burden of proof. But I think on the plus side, in the case of the US, is the fact that forced labor, so the prohibition of products made with forced labor, the first act dates back to the 1930s. So from that point of view, the US was ahead. So here I've tried to map out the differences between the two. So I think that in a nutshell, the CS3D is not really well aligned with the UN guiding principles, but we know that many of the limitations of the directive stem from compromise. Until the very last minute, there was a real concern from the European Parliament that it wouldn't pass at all. So it was very much passed at the 11th hour. So just moving on then to, my conclusion. So I think, to sum up, I think we have two set of challenges which Jean-Michel Servet also adverted to earlier. So one, internal, so there's a problem on the design, so the way they've been conceived. There are some problems there. I think there should be more focus on the perspective of workers and workers' rights. And then, unfortunately, at the moment, there are a lot of external elements, factors of a geopolitical nature. So isolationism, protectionism, tariffs, imposition of tariffs again, but more generally a concern in relation to blatant disregard for the rule of law approach. So it's not just about the WTO, it extends to other international organizations and courts as well. But I do want to try and see some light at the end of the tunnel. So I think on the one hand, internally, I think the litmus test is, national implementation, but also, as I said, the Commission being willing to review, to actually amend, to suggest some amendments of the directive to better comply with the UN guiding principles. And then there have been suggestions, I know there are some reservations, as have been mentioned earlier, in relation to maybe having a binding treaty. Of course, the problems with treaties is negotiations take a very long time, and in fact, the treaty was proposed more than 10 years ago, and negotiations are ongoing. But I think the difference now is that the EU is also on board, besides, I would say also surprisingly, China and Russia. Okay, so that's all. Sorry if I spoke extra time, but thank you very much for your attention.
Anyone has questions? There, you can think about it. So we can. Okay. Thank you.
So at the end, we can say that labor law is not cannot be the only tool. And I would give the floor to Luka Misic, our third speaker.
Okay. Prova. Allora, così. Prova, prova. Prova. Vabbè, fatto con hai slide?
Sì.
Dove sono?
Sono le prime che si sa.
Le prime.
Sì, no, le prime che non
Aspetta. Ale, qual è? Non lo so.
allora.
Sì, qual era? Ho un microfono qua. Prova, ora come mi senti? Solo fuori. Ho finito per questo. Va bene, facciamo andare. Sì. Ora nel slide non l'ho aperta.
And as I said, Luca is one of the coordinators of the ALIS association. He comes from University of Ljubljana, and today he will give us a presentation on a topic that often is not really considered, the social security problems related to corporate social responsibility. Thank you.
Yeah, Christina, thank you very much, and also thank you very much for inviting me and having me. Initially, I thought I wouldn't be able to make it. I had some other obligations in Ljubljana, but luckily I made it. And if it wasn't for Rome, I would just stick for the other obligations in Ljubljana. But this was a very strong incentive for me to make it, and I'm very glad that I'm here. I will start with an anecdote from a few years ago when I was approached by a foreign colleague who had the idea of us working together in the field of corporate social responsibility. And now, those who know me, I'm a very traditional social security lawyer. But I heard the word social, and then I heard the word corporate, which in a way is also relates, well, could relate to the field of social security. And then I started to sort of look into the field, and more I thought to myself, as a social security lawyer, do I really fit into a field which is predominantly governed by private or private international law? Because social security law is a very typical traditional public law matter. In some systems, it's part of administrative law. In some systems, well, in all systems, is basically all systems, it's linked to the field of labor law, and then, of course, it depends where labor law fits in. But at the end of the day, it's not a private law discipline. So I still think that in a way I do not fit in, or that social security law in a way does not fit in. But we'll get to that in a minute or so. So to begin with, just a few definitions. The European Commission defines corporate social responsibility as the responsibility of enterprises for their impact on society by integrating social, environmental, ethical, consumer, and human rights concerns into their strategies and operations alongside following the law. And now, when I first heard of the notion of corporate social responsibility or responsible business conduct, I didn't think of objectors, companies not following the law. I always thought or considered, or primarily considered, companies or employers who are socially responsible doing something more than what is the benchmark, what are the minimum standards, or what is simply the idea of following the law or following or living up to human rights concerns or constraints. In a way, I would be focusing on those or such companies in the remainder of my talk, and trying to find where companies, European companies, working, well, operating in a local environment could do more, and can that the more be associated with social security or not. Anyway, there's another definition by the OECD. The aim of the lecture today is a very short overview of EU soft law measures in the field, going back 10 years or so to the first communications, without looking at the UN, ILO, or the OECD. So this is a communication from 2011, coupled with a next steps communication from 2016. And what I was doing, I was virtually going through the documents and looking up for words like social security, social protection. And they're mentioned very, very rarely. In some of the documents, they're completely omitted. However, a lot of times, poverty is mentioned and social inclusion is mentioned, but not in the sort of narrow context of social security law. Because if the drafters of the communications had the narrow context of poverty, or the context, well, the social security context in mind, they would have, I guess, referred to social assistance, which is a particular part or subdomain of social security aimed at preventing poverty and social exclusion. But nowhere in the documents have I found any reference to social assistance, and very little reference to social security or social protection. However, of course, social security law, social security rights or social rights can be linked to other notions which are more often used or were referred to more often, such as employment targets, inclusive and sustainable growth, mitigation of adverse effects of the recent economic crisis. This is, I think, a citation from the 2011 communication. Of course, protection of human rights, because in a way, social rights or social security rights are sometimes still depicted as second-generation rights, referring to positive obligations of the state, in a way not as effective or directly implemented in a direct fashion, or in the same way as third-generation rights. Of course, as a social security lawyer, I have to promote the universal approach to universal human rights, meaning both first and second generation rights understood as a single concept. Anyway, employee health and well-being, integration of disabled persons, etc. Those are all notions which are linked, of course, strongly linked in a way to Social Security and Social Security law, but Social Security and Social Security law is seldom mentioned. And very interesting citation or wording from the 2016 communication brings me to the European way of life was in ensuring long-term competitiveness. And the previous speaker, you have mentioned, you referred to philosophy twice, I think, in your speech. And in a way, the European way of life made me think of what is the actual aim or what is the actual sort of nature of the project, of the corporate social responsibility project. Is this is it a communitarian project promoting the good life within closed European societies? Maybe going further, in respect to global supply chains, opening up the question of transnational or global social justice, or is it a liberal project aimed at furthering equal opportunities of workers, either in local or the global landscape? So I think in a way, of course, it's both a communitarian and a liberal project. So another document, a staff working document from 2019, Social Security and Social Protection were referred to 6 times, but mostly with respect to the Race Equality Directive, the Single Permit Directive, which allows third country nationals to work in Europe, the European Union, and the European Pillar of Social Rights, which back in 2019 was still a very recent document. Encouraging socially friendly business practices, the European Pillar of Social Rights was again mentioned in this respect. The promotion of social dialogue, cross-industry social dialogue, and transnational company agreements. Why is social dialogue important? Because companies could use collective bargaining to bring in additional social security rights, to allow for additional days of leave, higher benefits, etc. But looking at collective agreements, I'm not a labor lawyer, I'm a social security lawyer, but still looking at collective agreements, in the way I perceive them, they are mostly referred to labor rights, and seldom additional sort of social security benefits would stem from collective agreements. Most of the documents, a lot of times they refer to employment, unemployment, employment of marginalized or vulnerable groups. So if I would approach the documents through the prism of social risk, traditional contingencies, which lie at the heart of Social Security, because Social Security or these social insurance schemes offer income replacement or living cost reduction benefits in times of contingencies, paternity, maternity, sickness, etc. Mostly health. So sickness is referred to, and unemployment or employment is referred to. Those would be the two. So sickness and employment would be the two unemployment would be the two contingencies mostly referred in corporate social responsibility documents. And I think the latest, or one of the latest soft law documents in the field makes, interestingly enough, several references to social, again, well, not interestingly, to poverty, social exclusion, and inclusion. I've mentioned this before, but interestingly enough, it also does refer to integrated social protection systems, including public services such as education, training, lifelong learning, childcare, health, and long-term care. But some of those concepts go way beyond the traditional notion of social security. They refer more to the concept of the welfare state at large. So generally, looking at the soft law documents in the field, several references to social protection schemes were made recently, but what is important they all refer sort of to the level of the member states or the local level of regions, not the company level. And this is why I began thinking of social security being either relevant or really irrelevant for the topic of corporate social responsibility, because social security is nothing else than public income replacement or public income protection. It falls within the competences of the state legislators, and whichever sort of measures, similar measures are passed at a company level, most of them, well, it's questionable whether they would still fall under the traditional notion or concept of social security, because social security is public. And I will give a few examples here, and I think this is I think this is one of my, either my final or penultimate slide. Let's think of additional measures that companies can come up with to offer a higher level of economic protection to their for their employees. So insurance. If they introduce private health insurance arrangements, this is not social security. This is private arrangements. Life and disability insurance, as long as they're private, they do not fit into the traditional notion of social security, where there is great opportunity, however, for companies to offer more than what is the bare minimum of just following or abiding the law is the second pillar pension insurance schemes, which offer additional old age pensions to employees. And of course, this opens up the question of equal or unequal treatment, because then suddenly one socioeconomic position becomes dependent on the company they're employed by or the sector they're employed in. In-work benefits, think of stock options, equity participation, childcare support, for example, additional days of leave, or kindergarten financed by the employer. Those are all measures which, of course, relate to the notion of social security through the notion of income security, but again, it's private and not public. So generally, what I've found is, and of course this applies to the directives as well, not only to the soft law measures or documents I was looking at, generally very little reference is made to social security or social protection. I haven't seen any reference to social assistance, which is interesting because a lot of reference to poverty and social exclusion or exclusion, which through the prism of social security is basically a social assistance. However, all those notions are, of course, linked to other aims, inclusive of sustainable growth. We cannot have inclusive of sustainable growth without sustainable social security systems. As mentioned, common reference to poverty, social exclusion, and unemployment being the most interesting contingency from the point of view of corporate social responsibility soft law documents. So I will end this short presentation by, well, still being in doubt. As a traditional social security lawyer, I'm not sure whether I fit into the field or whether this subject fits in well into the field of corporate social responsibility. Even more so looking at if I stick to the EU context, even more so looking at the very limited competences the EU has in the field of social protection, in the field of social security. Basically, they're limited to social security coordination, and in a way to equal treatment of men and women. But apart from that, the competences lie with the national legislators, who are in charge of the closed welfare states as sort of bounded communities. And yeah, I would be looking. I'm looking forward to any questions, but also to your reflections on my question whether the traditional concept of social security is relevant or not for the whole sort of debate we're having today in or on the topic, in the field or on the topic of corporate social responsibility. Thank you very much.
Thank you. I think that one issue might be the accountability of the company for the contributory default, for example, of the suppliers. So, because there is a connection between the contribution of the suppliers and the social protection of the workers in Italy, at least. So maybe this can be one of the problems. I know it because I told you I was reading something about this regarding a problem that was not really global supply chains, but something related. We have, as European Union, some sustainable fisheries partnership agreement, so signed by the European Commission with other with third states, so African states most of all. You have European fishing vessels which operates in with the African workers. And the problem was that the agency was, because then another problem, you have an agency who employ the workers. So this is a case of the intermediation. In this case, even if the fishing vessel is European, the agency is not European, and there were some troubles for workers to the enforcement of the law. And in that case, one of the problems was that they didn't have a social protection because of some default by the agency. And I don't know how it works, the system there, because for us we have a really public involvement. But if you have some default by the agency, the problem was that there weren't social protections for those workers. So one of the issues was the social protection part of these workers, where and also the wage, the low wages is related to the position, to the social protection of the workers.
Yeah, of course, because low wages lead to low income replacement benefits. Yeah, of course, there is the link with labor law, but at the end of the day, for me as a social security lawyer, I would just look for okay, does Lex Loci Laboris apply? Does Lex Loci Domicili apply? I would check for the national legislation, see whether social security contributions have been paid, check, and whether the legislation is in line with EU law and international standard. Is this socially responsible? I think this is the bare minimum.
I agree. Thank you. Any questions? Thank you, Luca. So I think we can have a small break, coffee break, and then we have the contribution of young scholars. So. Una alle slide
Anna Catalina. Anna Catalina. Sì, ma sei? Anzi, ancora meglio.
And this one, the other, I would say the other one is this is where I guess you can think on this. Or go to step further. No, he's not directly. Okay, da, treba će još dobro. Poslije.
Ako budeš imao vremena.
Da, ako imam vremena, da. Ne znam kad je doći.
Mogu je doći ranije tamo, nego da te ne treba.
Ne, kako se?
Početi 9:15. 9:15.
Ne, u 10. Dobro, vidite,
Nisam mogla danas reći cijela sam vidjeti.
Scusami. Allora, il discorso è già scaricato. Guarda, solo qua, apri qua. Apri qua. Pacifico. Con i pennelli.
Perfetto.
Dopo ci sei tu o c'è perché io
No, io sto alla
no,
fine.
c'è prima Casalino, però sono già aperto le Casalino. Controlla.
E quindi avremo il computer questo qua davanti.
Qua parli dal microfono, anche se non si sente Sara, però abbiamo bisogno che utilizzate anche questo.
Sì, perché sennò a casa non ti sento.
Come si fa a cambiare?
Allora, dopo che te la metto io, come una presentazione.
Ok.
Così. Un attimo, la metterò così se preferisci. Ecco, la metto verso il basso, ma la prendo.
Ok, non a destra. Ok, basta. Grazie mille.
Perché è diffuso. Ma se, allora, se tu fai apri il microfono, sono questi due, se tu accendi questo, chiudi e riapri. Aprito? Dovrebbe essere questo, poi no.
Questo è un relatore che si è collegato, ma dovremmo sentire la mia luce. Perché non la senti?
Mi sto facendo, interrompe la condivisione, se no vedono tutto quello che facciamo.
Faccio interrompe?
Magari finiamo.
Allora,
Il share è questo qua. Il Pro funziona bene, il Pro è difficile. Quello questo datore di Pro, no? Forse perché è spento, aspetta. Paolo, mi senti? Mi senti Paolo? Non mi senti, vero? Qua dovrebbe essere questo. Questo dovrebbe essere questo quello che attivo. Sta appena acceso. Sta solo la cosa. Guarda. Funziona bene. Prova, prova. No, ma adesso questo di qua non lo leggo, secondo me lo devi mettere tu. Secondo me lo devi mettere tu. Before that as well. If you like to work, c'è il microfono, dovrebbe essere questo.
Grazie, a domani.
Dopo in un secondo momento facciamo il montaggio, prendiamo l'audio da qua, esatto, e poi eventualmente anche il video da qua, però se eventualmente dobbiamo skippare possiamo fare lo stesso.
E poi secondo me facciamo una sì, facciamo una dentro il pagamento, mamma è un muoio.
Poi ci sono gli altri due, così va. Io oggi sono da solo per imparare, quindi non ceno, però almeno ascolto. Molto interessante. Sì, molto ampio. Coordinatrice. We can start with the second part of this session. And thanks again to all the speakers. So now I give the floor to Anna Casalino. I don't know the content of your speech, so
okay,
up to you.
will be a surprise. Okay. Good afternoon, everyone, and thanks for inviting me today. I'm Anna Casalino, and I'm currently studying as a research fellow here at the Mercatorum University here in Rome. And today, according to the main title of this seminar, and also taking into account my personal main research interests, I will try to share with you some very short considerations, my main idea about corporate social responsibility, with specific reference to the impact of corporate social responsibility on small and medium enterprises. The reason why I decided to talk about the impact of corporate social responsibility on small and medium enterprises is mainly due to the fact that I'm Italian. Most of us are Italian, and we are all aware of the fact that in Italy, our economic context mainly consists of small and medium enterprises, particularly those into the made in Italy production. So for us, here in Italy, the small and medium enterprises have historically played a crucial, a pinnacle role, not only in our economy, but also in our society, also in the development of some contexts of some areas, of some territorial regions of our country. So not only they have improved some territories, but they have always been very sustainable, which means that they have always paid particular attention to, for example, using products, using materials coming from resources coming from the very nearby of the region of the city where the company is based. They have also always established contractual relationships with other small and medium enterprises based in their same territories and conducting the business in the same sustainable way. And I would say that also from a labor law perspective, they have always paid great attention to the human capital of employees. Just worth mentioning the handmade productions and the skills, the personal skills of employees in the Made in Italy small and medium enterprises. And I like to say that in some territories, in some areas, small and medium enterprises also represented for some employees an occasion for redemption. So I like to say that small and medium enterprises, especially those in the Made in Italy production, were the forerunners maybe in Italy of corporate social responsibility. And they have always benefited of this commitment from a reputational point of view, because I believe that internationally in the whole world, Made in Italy products are famous for being products which were made by human beings, by employees with extraordinary capabilities in tailoring, in manufacturing. Made in Italy products produced by small and medium enterprises are internationally recognized for being produced with materials which come from the very nearby of the territory where the company is based. So starting from this perspective, I started to ask myself which would be the impact of the corporate social responsibility on small and medium enterprises, because for us in Italy, they play in our economy and society, they play a crucial role. So I believe we have to protect these their role in our economy and in our society. But for sure, we are strongly concerned, absolutely concerned of the idea that a huge effort in terms of bureaucracy, very high costs in order to be compliant with European directives, for example, in terms of reporting directives, could be too much, could affect their business. So I started wondering about the impacts of corporate social responsibility on small and medium enterprises. And starting from the assumption that there isn't a clear definition of what corporate social responsibility is. If we consider formally the corporate social responsibility, if we want to adopt a very technical and formal definition of what corporate social responsibility is, and we say that it is the result of the efforts of the European efforts as enshrined in these directives, the first document we have to start from to talk about corporate social responsibilities and its impact on small and medium enterprises is the very recent proposal for a directive of the European Parliament and of the Council amending these European directives, which was also mentioned by Professor Servet, which was published last February 2025. To sum up, what this proposal of the European Commission makes clear is that we have absolutely to reduce, to limit the obligations in terms of the formal, the bureaucracy, the obligations that small and medium enterprises have to accomplish, have to deal with. Also referring to the Budapest Declaration on the new European competitiveness deal. It's important to limit the obligation, to reduce the obligations for small and medium enterprises in order to improve their competitiveness. So what is written in this proposal can be summarized, in my opinion, in 2 points that I consider particularly interesting. Because on the one hand, For sure, the proposal says we have to reduce the obligations, the formal obligations for small and medium enterprises in order to allow them to be more competitive. But on the other hand, the proposal also provides an alternative for small and medium enterprises, which is a voluntary sustainability reporting recommendation. So is a voluntary standard for small and medium enterprises, which is maybe more suitable for small and medium enterprises. And in my opinion, also much better reflects the way that small and medium enterprises, especially in Italy, have always conducted their business. So which would be the possible consequences, the possible pros and cons of this proposal, which aims to reduce obligations for small and medium enterprises? For sure, the first one is a reduction and simplification of administrative obligations. For sure, there will be a significant saving on sustainability reporting costs for small and medium enterprises and a greater competitiveness for these companies. But I think that on the other hand, small and medium enterprises will be required to deal with a huge challenge, which is becoming a valid and reliable contractual partners for bigger companies that will establish with them contractual relationships. Otherwise, the risk that I feel we can anticipate is the risk that small and medium enterprises could be just used sporadically by bigger companies just because it's easier to deal with them, because they are subjected to a lower to more limited, more flexible obligations in terms of corporate corporate sustainability, of corporate sustainability. So in the event, just sporadically, small and medium enterprises would be involved by bigger companies, I feel that small and medium enterprises could really suffer impacts in a more significant way from a sporadic collaboration with bigger companies. Another interesting aspect of the proposal, and this is my last slide, is that in the proposal of the European Commission, there is no reference to the labor law perspective to corporate sustainability, which is not coherent, in my opinion, because there is a huge correlation between corporate sustainability and human resources practice, because for sure, if a company is much more committed in sustainability, in human rights, for sure, he will retain high quality and high skilled employees. And on the other hand, also employees are more committed to work for a company if this company shares their own values. But what is extremely interesting, in my opinion, is that this correlation between the commitment of the company in guaranteeing a high level in terms of respect for human rights, in terms of sustainability, and the relationship with the employees, is that this correlation, in my opinion, is much stronger precisely in small and medium enterprises, where the relationship with the employer is much closer, and where the employee does not work for a company, for a very big company, which is based, or which production is based in a completely different part of the world than the one where the employee is living. But in small and medium enterprises, the employee is also a citizenship living in the same territory, in the same city where the company is based. So the employee in small and medium enterprises is also the person that would benefit or not of pros and cons of how sustainable and how committed in corporate social responsibility that company is. That's all. Many thanks for your attention.
Thank you, Anna. In the end, we
We thought about the proposal only on the critical part, and she gave us also some different considerations. So we can move to the other speakers. Camilla Benavides. You don't have slide, so thank you. Curitiba University.
Okay. Okay.
Maybe I didn't say that Anna Casalino is a post-fellow in our university, so in Mercatorum University.
Just moved a little bit his computer. I think it's not a problem. Okay. Good afternoon, everyone. First, I would like to acknowledge the great work of these organizers in this event and thank them for the opportunity to be part of this session. My name is Camila Benavides, and I'm from Brazil. As a Brazilian, I would like to acknowledge the work and the intervention of Professor Jean-Michel in our situation with our President Lula. His intervention and the intervention of ILO, it was very important for us as a democracy, and I would like to thank both. As I said, I'm from Brazil, but for the past 5 years, I've been living in Italy. And now I consider myself half Italy, half Brazilian. And I work remotely in Brazil as a visiting professor in the Pontifical University Católica of Paraná. And I also work as a labor law, always remotely. This is important because this remote work is the main subject of my research, and I think that's because I live the situation in the practice. Today, it's also a very special day for me because it's my first day here at Mercatorum after my postdoctorate project was selected, and I was very grateful for this opportunity, excited about the next 2 years of research. As I just mentioned, I'm just in the beginning of my journey. I have my project, some initial data, and a lot of hope, but no results yet. So I will share with you today some ideas and reflections about the topic of this event, and I will try to link this topic with my research. The social responsibility of companies is especially important today, as we saw in this afternoon, in a world where work is always changing. Work is no longer limited by national borders or physical offices. We are now living in a new age with emerging forms of work, such as transnational remote work, which is my focus in my research. During my PhD, I studied how remote work across countries creates new challenges, new legal challenges, especially related to the conflict of law and jurisdiction. But my research was limited within the European Union, looking at the contracts between companies and workers inside the EU. For example, I studied a case of a Portuguese company who hired an employee who lives in Romania. He works 100% online from his house in Romania, and he never went to Portugal. And he never visited the headquarters of the company. During my PhD, my questions were, which national labor law applies to this contract? Which court is competent if a dispute arises in this type of international contract? And these questions show me how hard it is for national legal systems to regulate international remote labor relations. Now, as I begin my postdoctoral research, I will expand this analysis to a global perspective, compare legal responses in different regions of the world, and evaluating how private international law could help to create more fair, clear, and effective rules for global remote work. But how does this situation connect to the corporate social responsibility? Let me offer two reflections. First, in the context of corporate social responsibility, remote work may be seen as a tool to promote decent work, especially for people in regions or countries with fewer job opportunities. But without regulation or without hard law, as we saw this afternoon, this flexibility may become a new form of exploitation. For example, some workers are classified as independent contractors without social protection or job security. So companies that hire remotely across borders have a social responsibility to ensure that workers are not excluded for labor rights simply because they are working from abroad. The corporate social responsibility must include digital workers, platform of workers, and remote workers, wherever they are based. A second risk that I would like to talk about in this afternoon is the social dumping. When companies choose to hire remote workers in countries with lower labor standards or weaker protections, simply to reduce costs, this can lead to an unfair competition and race to the bottom in working conditions. A truly responsible approach must avoid use geographic and legal differences as a tool to bypass labor rights. Social responsibility means not just respecting the law, but also promoting fair treatment across the entire workplace, no matter the worker are located. Another important aspect in that multinational companies now rely on remote labor in the same way that previously rely on global supply chains. Outsourcing not only production, but also services, designing, content creation, and custom support. However, while transparency and due diligence are increasingly required in physical supply chains, similar standards are often absent in the digital or remote work context. The new Corporate Sustainability Due Diligence Directive, for example, may open the door to extending responsibility to include remote and digital labor. This could help ensure that companies remain accountable, not only for workers in their factories or logistics chains, but also for those in their virtual offices. In conclusion, I believe that transnational remote work must be included in the discussion about social responsibility of the companies. Is it a growing reality that challenges legal borders, but also offers a unique opportunity to rethink our labor protections and to promote a more inclusive and responsible global labor market? As I said before, I am in the beginning of my journey. I don't have answer. I have a lot of questions, but I really appreciate this opportunity to speak here today, and I'm available for any questions. Thank you.
Any questions? Okay. Thank you, Camilla. Now, our last but not least speaker,
Francesca Pacifico from the University of Benevento.
Aspettiamo le slide. Sì, adesso le aspettiamo. Fammi vedere se viene perché non so.
Dov'è? Va. Qual era? Pacifico?
Sì, grazie.
Comunque c'è ancora caldo qui dentro, non ho cambiato niente per le condizioni. Vero? Se vuoi posso aprire, se preferisci.
Sì, va bene. Adesso c'è silenzio.
Ok.
Thank you. First of all, I would like to thank the organizer for the opportunity given to me to participate in this prestigious conference, which has already offered many valuable insights. I'm Francesca Pacifico, and I'm a Doctor Europeus, and this work comes from a shared reflection with Pierre Petris, who unfortunately cannot be present today. Our central question: what is the real, legally relevant impact of corporate social responsibility and due diligence within the sustainability paradigm on labor law today? This talk focuses on 4 key themes: changing employer responsibility, new role of collective bargaining, legal value of worker participation, future of labor law. Today, we are witnessing a structural shift from voluntary CSR to a new model based on prevention, supervision, and liability. Labor law must adapt to this new sustainability framework. Let's start with the first issue. How is the employer's responsibility changing? We can say that this change is a quiet but powerful revolution. Employers are not responsible not only for their direct employees, but also for workers throughout the entire global value chain. Companies must proactively identify, prevent, and address negative impacts on workers, signaling a transformation of the employer into a systemic actor within the broader economic structure. Violation of these duties result in direct civil liability, administrative sanctions, legal standing granted to unions, NGOs, and stakeholders to take action. Legal reforms are required to align with these expanded responsibilities. Let's pass to the second issue. What is the role of collective bargaining? The new legal framework combines EU law, ILO standard, private codes, contracts, and the reporting obligation. Even company ethic codes can become binding when mandated by law. Collective bargaining gains renewed importance as a tool for shaping and monitoring sustainability standards. As for the fourth issue, what is the legal value of worker participation today? Worker participation is now mandatory, not optional. Companies must involve workers in risk assessment, prevention planning, business decisions, remediation efforts. These redefine participation as a condition of corporate legitimacy, requiring stronger national framework. It represents a profound shift. It requires a rethinking of national laws, particularly Legislative Decree number 81/2008 on workplace safety. It demands the strengthening of mechanisms for worker information and consultation, which remain
fragmented, and often ineffective. It must become part of building the company's sustainability strategy. What about the future? How should labor law respond? Labor law must extend protection to indirect and supply chain workers, recognize private standards when linked to public obligations, empower worker representatives, redefine the employer functionally, and ensure transparency, monitoring, and compliance across the chain. To conclude, we can say that the CSR and due diligence are not marginal. They reshape the core of labor law. Labor law is now called to embrace sustainability not as an external principle, but as an internal criterion for legitimizing corporate power. We must move from a contract-based model to one of distributed responsibility and sustainability work, ensuring that dignity and human rights remain central, even in a global economy. Thank you for your attention.
Thank you, Francesca.
Thank you
for
to
your presentation. Do you have any questions? So we finished with a topic that remained one of the main issues, I think, so the workers' participation and maybe the transactional collective agreements, I think. I want to thank again everybody who was here today and our speakers, the young scholars who contributed to the discussion. If you don't have any questions, so I think we can finish with this first session of this seminar. And I'm sure that tomorrow we will have other, what's happening? Okay. So, but I can continue. Okay. So last 30 seconds and then it's, but anyway, tomorrow we will continue the discussion, and I think there will be more contribution about the European Union, our law approach. So CSRD directive, CS D directive, and the regulation for labor. So thanks again to everyone, and see you tomorrow at Sapienza University.
See you at Sapienza tomorrow.
Yeah, Sapienza University.
What time tomorrow?
10. Thank you.
Non posso venire domani, ma mi ero organizzata